Last night I received an email from someone who wanted me to take a look at the Maya Kowalski opinion from the Florida's 2nd District Court of Appeals. I've done that. I told him I would do a video on it, so that's what follows. Here's what we're talking about today. Here's a quick summary of the case involving Maya in Florida. Maya, then age 10, was treated at Johns Hopkins All Children's Hospital in St. Petersburg for debilitating pain that her family contended was due to complex regional pain syndrome, CRPS. The hospital and child protection authorities suspected Maya's mother, Beata Kowalski, of medical abuse or Munchausen by proxy. Maya was removed from her parents' custody and held at the hospital for over 3 months. The lawsuit alleged multiple claims, including false imprisonment of Maya, intentional infliction of emotional distress to Maya and to the estate of Beata, who died by suicide, and fraudulent billing of Maya's father. So, the trial lasted for 8 weeks in September of 2023, and after that 8-week trial, the jury deliberated 16 hours over 3 days to reach the verdict. The verdict was for $261 million, of which $211 was compensatory and $50 million was punitive. And in July 2024, the trial judge remitted the amount of the award by about $47.5 million, bringing it down to $213 million, and then the hospital appealed the judgment. So this is the opinion on appeal. So this opinion was written by Judge Black, and it says the final judgment awarded damages to Kowalski's for false imprisonment between October 7th and October 13th, and the trial court's erroneous interpretation and application of Section 39.2031A Florida statutes and the immunity afforded thereunder, as well as the trial court's erroneous denial of the hospital's motion for directed verdicts and for a new trial, require reversal of the final judgment. So here's the background according to the opinion. In fall of 2015, Maya was diagnosed with this CRPS. Beata Kowalski, who was an infusionist, a nurse infusionist, became aware of this condition prior to Maya's diagnosis through one of her patients. Patients with CRPS experience an array of symptoms, including agonizing pain in the affected region or limb, extreme sensitivity to touch, light, and lesions. Initial treatment included warm water therapy, physical therapy, non-narcotic pain medications, and then opioids. When initial treatments failed to relieve Maya's pain and symptoms, Maya began receiving ketamine. Now, ketamine is a powerful dissociative anesthetic medication used in both human and veterinary medicine. It can produce a state of sedation, pain relief, immobility, and amnesia. Ketamine is used primarily in controlling clinical settings for anesthesia. It's effective, it's short-acting. And so for surgeries and procedures that are short, especially in patients with respiratory issues due to its bronchodilating properties, it is used for those kinds of things. It's also used for pain management to treat chronic and neuropathic pain. Ketamine-derived nasal spray has been approved for treatment of resistant depression, and it can be used in emergency situations to treat refractory status epilepticus, or prolonged epileptic seizures, and acute agitation. Ketamine is not a benign drug. It's close in properties to propofol, the drug that killed Michael Jackson. Both are procedural short-term anesthetics. So when the initial treatments failed to relieve the pain, she began getting this ketamine. This included Mrs. Kowalski taking Maya to Mexico, where Maya was placed in a 5-day ketamine coma, which is as dangerous as it sounds like it might be. She was there for about 8 months before her admission to the hospital, and she got ketamine through a central venous port in her chest. And central venous ports are notoriously subject to becoming infected and causing sepsis. So, again, this is not a benign procedure. She also had prescribed other treatments, including hyperbaric oxygen and immune system stimulants. During most, if not the entirety of her treatment, Maya was unable to walk without assistance and was in a wheelchair. On the day before Maya's admission to the hospital, Dr. Hanna advised Mrs. Kowalski that he'd given Maya the maximum dosage of ketamine that could be administered, and that it was not helping Maya. Dr. Hanna advised that Maya be taken to Johns Hopkins, and on October 7th, that's where they took her. Maya presented with excruciating pain. Upon Mrs. Kowalski's arrival at the hospital, she was adamant that Maya received ketamine infusions, and although the hospital was able to confirm with Dr. Hanna that Maya had been in his care, he had been receiving these high doses of ketamine, the hospital emergency room notes state that dosages at the level demanded by Mrs. Kowalski could not be administered in the ER. And it noticed there that Dr. Hanna did not testify at trial. Concerned about her demands for ketamine and perceived inconsistencies between her recitation of Maya's medical history and the hospital's own observations, a social worker, in accordance with the hospital policy, called the Department of Children and Families Abuse Hotline on October 7th. The following day, October 8th, the hospital contacted Dr. Sally Smith because of suspected abuse. Smith, who had privileges at JCHCH, is a pediatrician and was the medical director of the Child Protection Team for Pinellas County at that time. On October 9th, the second call from a social worker instituted an immediate investigation. On October 13th, Maya remained at Johns Hopkins but was taken into the department's custody. The department filed a dependency shelter petition requesting that Maya be presented or placed into their care. The department sought this because they wanted no contact between Maya and Mrs. Kowalski, and they did that, and they said they could only be supervised visits. The dependency court provided that Mrs. Kowalski was to have no contact with Maya pending psychological evaluations. Additionally, the order provided in the event Maya's parents were unwilling, the department or the person primarily responsible for the care was authorized to consent to ordinary and necessary medical treatment and examination. So, the main issue here is that they believed that Maya presented not with CRPS, but with something a lot more rare called Munchausen syndrome by proxy. Now, Munchausen syndrome is a psychological disorder in which a person deliberately fakes or causes illness or injury to themselves to get attention, sympathy, or care from other people. They might lie about symptoms. Oh, I have such pain. They might tamper with medical tests, or even harm themselves in order to appear sick. The motivation is usually not money or a legal benefit, it's the emotional reward of being seen as ill and getting care and love from people that you need to get that from. Well, Munchausen syndrome by proxy, which is now more often called factitious disorder imposed on another, is when a caregiver, usually a parent, intentionally causes or fabricates illness in someone else, typically a child, to gain attention or sympathy. The caregiver may exaggerate symptoms, give harmful substances, or manipulate doctors into believing the child is sick. It's a serious form of abuse because the victim, the child, is actually harmed by unnecessary treatments or neglect of real health. In short, Munchausen's is faking it for yourself, and Munchausen's by proxy is essentially causing illness in someone else, a fake illness in someone else. So the opinion goes through a lot more of the facts about how the hospital threatened them with arrest if Maya were to leave the hospital against medical advice. Evidence at trial established that Johns Hopkins attempted to transfer Maya to another hospital, but the Kowalskis would not consent because the insurance codes on the transfer form indicated that Maya had this Munchausen syndrome, and they didn't believe that they did. Mr. Kowalski testified that he and Mrs. Kowalski would not sign the transfer form because they believed it would mean admitting guilt or blame. Well, it could very well be that there was guilt or blame, as we'll see here in a little bit. Without referring to the limitations or requirements of the dependency court orders, Mr. Kowalski testified that anything he brought into the hospital had to be approved, whether it was clothing, food, or letters. Food was required to be prepackaged and could not be homemade. Mr. Kowalski testified that during one of his visits, Maya had asked him whether Mrs. Kowalski was in a mental institution. Mr. Kowalski testified to additional statements made to him by Maya, including instances where the nurses told Maya that her illness was all in her head and where Ms. Beatty told Maya that she could be Maya's mother while Maya is there in the hospital. Mr. Kowalski also testified regarding his own interaction with Ms. Beatty, where she asked him, "Did you ever consider divorcing your wife?" He responded, "What are you talking about?" And Ms. Beatty said, "Oh, forget it," and walked away. Mr. Kowalski relayed to Mrs. Kowalski what had happened during his visits with Maya and the information that he had learned. Although he was aware that Maya had been moved to a new room, he testified he didn't know that it was under video surveillance. He never saw nurses taking actions that he considered to be cold or unusual. Maya testified that she was furious because she couldn't speak with her mom. One instance Maya relayed involved a specific nurse verbally accosting her for not moving during a bed change. Despite Maya advising the nurse that she could not walk, stand, or roll, the nurse said, "If you don't move right now or else," she recalled that the nurse yelled at her for quite a while, saying, "I know you can move. I know you're faking it. Just stand up. We all know." The Kowalskis are Catholic, and Maya testified she wasn't able to get communion from her parish priest, although the priest that serviced the hospital did give her communion. They didn't allow this because they were afraid that Mrs. Kowalski would tamper with the communion wafer with it somehow, and maybe add ketamine to it, which is really a strange thought when you get down to it. Maya reiterated in her own testimony that Ms. Beatty had told her that her mom was in a mental institution, and Maya quickly learned that her statement was false. Mrs. Kowalski was born in Poland, and Maya also spoke Polish, so they often talked that way. They told them they could not speak in Polish while she was in the hospital and Maya was there and her mom was not able to come physically visit her. They could talk on the phone or have FaceTime, but they had to talk about insignificant things and they couldn't speak in Polish. So they put quite a few restrictions on her, and a final instance involved Mrs. Beatty occurred when they told her that they had to strip Maya naked and photograph her before she went off to this hearing. Apparently, that was mandated by the risk management people. It wasn't the idea of the social worker. They played her deposition, Betty's deposition, for the jury. She testified that court orders provided general parameters, but that the department and Johns Hopkins, to some extent, determined how to implement those parameters. So much of Mrs. Beatty's testimony concerned actions authorized or required by Chapter 39 and responses to questions mischaracterizing Johns Hopkins' continued involvement as taking this child away from her parents. Again, you can do a lot of harm in a cross-examination or the examination of an unfriendly witness by mischaracterizing their testimony, and that's apparently what the plaintiff's attorney did here. So, to make a long story a little bit shorter, in one case, Ms. Beatty wrote that she was furious, angry, and in pain. She told me she can't talk or trust anyone, and that she knows there's court on Monday, and it's all lies. Ms. Beatty testified that the department asked Johns Hopkins to monitor Maya's calls, and that at times they came through Ms. Beatty's phone, and she would put her phone on speaker to allow Maya to have the conversation. At no time did the dependency court authorize in-person visitation between Maya and Mrs. Kowalski. Ms. Beatty testified in January 2017 that the risk management department, as I said, told her to take those photos. On January 6, 2017, the dependency court ordered that Maya would remain sheltered at Johns Hopkins and set a February 2017 trial date. Mrs. Kowalski committed suicide the following day, January 7, 2017, leaving 2 suicide notes. Those notes reflect Ms. Kowalski's sadness and frustration with the dependency court proceedings and those involved with dependency proceedings, including Johns Hopkins, the department, and Dr. Smith. 1 week after the suicide, the dependency court allowed Maya to be released and to resume living with Mr. Kowalski. At the time of trial, the only medications she routinely took were Claret and Flonase and a sleep aid. She had been able to walk, run, and ice skate. Maya testified that she experienced no flare-ups in the 3 years following her discharge from Johns Hopkins. Now that makes me a little bit suspicious because it would appear that once her mom was out of the picture telling her how sick she was, she realized she wasn't nearly as sick as she thought she was, and whatever limitations she did have on her mobility were probably due to the lack of passive range of motion exercises when she thought she couldn't move. You have to move your limbs and you have to move the muscles. And a lot of times nurses do that for patients in a hospital when they're bedridden. And that may not have occurred. And that may have been part of the reason why she couldn't walk or move. Now she's able to do all of those things. So it does cast doubt on the CRPS diagnosis, and it does underscore the Munchausen's diagnosis. So where did all of this go wrong? Well, let's find out. The court starts off with the standards of review where they do statutory interpretation de novo, meaning they don't give the trial court any leeway in that regard, and that a motion for directed verdict presents a question of law, the sufficiency of a party's evidence, and they review that de novo. They evaluate that testimony in the light most favorable to the non-moving party, which in this case is the Kowalskis. And then they talk about the review of a denial for a motion for new trial, and they say that's abuse of discretion. In reviewing an order on a motion for new trial, an appellate court should consider the totality of all errors and improprieties. In Missouri, that's a different standard. There's a different standard for the review of a motion for new trial. It's justice and abuse of discretion. And basically, that means if reasonable minds could disagree, then there's no abuse of discretion. So this is a little bit more lenient of a standard in Florida, which I think is a good thing. The next thing they talk about is the immunity issue, and this was always at the heart of this case. Immunity is granted by the legislature for certain acts, and usually it's acts that are unintentional and that are designed to further a good thing, but may be erroneous. You see your neighbor next door and it looks like he's threatening his child with a hatchet. You call the Child Protective Services, they come out and they find out that the guy was just, showing his son how to safely use a hatchet. Your mistake for looking over there and seeing what looked like angry words, but in reality it wasn't. So if that man tried to sue you for reporting him, he'd be out of luck because you had a good faith belief that he was getting ready to harm his child. That's the whole purpose of the immunity provision. It's there to protect people who report in good faith. Now, there are people who report in bad faith. Somebody gets browned off at somebody else, and they decide, well, I'll fix them. I'll just report them to Child Protective Services for some kind of behavior that would not be appropriate between adults and children. And as a result, they come out, they do a big investigation. It gets into the newspaper. You can sue that person if you can prove A, that there was absolutely no basis in fact for him believing that, and B, that he did it in bad faith. So there are exceptions to the immunity provision, but this was always the biggest hurdle that the Kowalskis faced. The hospital is, in most cases, immune if it makes a good faith report of child abuse. And in this case, they had ample reason to suspect that this was child abuse. I've been in the situation where I believed that a patient was being abused, and I went to the pediatrician that was treating that patient, and I told the pediatrician, and he said, I'm not getting involved. So I went down to the administration and I said, he's a mandatory reporter. I told him what's going on. If he's not going to make a report, I'm going to make a report. And the administrator went up and told him he was going to make a report and he was going to do it from the administrator's phone so that the administrator knew that it got done. So most hospitals do take this kind of thing pretty seriously. Back to the opinion. Pre-trial, Johns Hopkins moved for partial summary judgment on the immunity afforded by this Section 39. They argued as relevant to this appeal that every claim against it except the battery claims was precluded as a matter of law because Johns Hopkins had reasonable cause to suspect child abuse and was otherwise participating in Chapter 39 proceedings. So there are two signposts, if you will, in this ordeal for the hospital. The first signpost is there is reason to suspect child abuse. So You're a mandatory reporter. You have to report it. There's no question that a report mandated by law is made in good faith. The second signpost, if you will, is where they participated in the care after that report was made, where essentially Mrs. Kowalski was written out of the picture in terms of her child. So those are the two areas where the court argued, or the hospital argued, that a new trial was warranted on the trial court's narrow interpretation, because the court granted in part and denied the motion based on its interpretation, and it was an erroneous statutory interpretation. So they also seek a new trial on any claims that remain after this court gets through reviewing. So the trial court considered two sections of Chapter 39. The one that says any person who knows or has reasonable cause to suspect that a child is abused, abandoned, or neglected by a parent shall report such knowledge or suspicion to the department in the manner prescribed by subsection 2. All right. So a couple of words that are really important here. One of them is shall. Shall means that you must do it. It's not a discretionary act. If it had said may report, that means you have the discretion to report or not as you see fit. But where it says shall, you must do it. And then the second section was, and basically this applies to physicians, nurses, hospital personnel engaged in the admission, examination, care, or treatment of persons. So respiratory therapists would indeed be people who are in that category, as well as health or mental health professionals. They're required to provide their names to the abuse hotline when making that report. The suspected child abuse by a parent must be reported immediately, and any person who is required to report known or suspected child abuse and who fails to do so commits a felony. So, Section 39.203 addresses actions authorized or required by Chapter 39. Any person, official, or institution participating in good faith in any act authorized or required by this chapter, or reporting in good faith any instance of child abuse, abandonment, or neglect to the department or any law enforcement agency shall be immune from any civil or criminal liability which might otherwise result by reason of such action. So that's a pretty broad grant of basically liability protection, of immunity. So they have to construe it broadly, and that's what the facts say, and that's what the law says. The court said that it could very easily, from the above cited precedent, determine that the hospital had reasonable cause to suspect child abuse. But the court said nothing of the immunity for claims resulting from participation in good faith in any act authorized or required by Chapter 39. The facts of this case are unusual in that the reporter, for purposes of Section 39.201 and 203, remained a participant in her care beyond the initial shelter hearing and was required to comply with the dependency court orders by virtue of the department designating her placement within the hospital. Moreover, the orders directed the court could not micromanage or countermand the policies, and that absent clear and compelling reasons, the staff was free to be accessed and address the medical needs of their patients without the court, parents, or others interfering with their professional judgment. So they were required to take part in sheltering Maya by virtue of the order signed on October 14th. The department sought to have Maya sheltered based on the ongoing abuse and imminent danger. Within the text, the legislature established its intent expressly. The purposes of this chapter are to provide for the care, safety, and protection of children and to prevent the occurrence of child abuse, neglect, and abandonment. The legislature further stated its intent that Chapter 39 be liberally interpreted and construed in conformity with its declared purposes. Courts may not extend, modify, or limit the statute's express terms or its reasonable or obvious implications, because to do so would be an abrogation of legislative power. So here the trial court erred by not considering the entirety of Section 39.203, and nothing in the record suggests that the hospital's implementation was not done in good faith. As such, the department is an institution participating in good faith, and it was immune from civil liability which might otherwise result from its action. The statutory scheme is intended to protect those who might be overzealous in protecting children from potential abuse. And that's not to say that it provides absolute immunity, because it does provide exceptions. It doesn't protect against failing to carry out protective measures. There are complexities within the statute, within the interplay between that and the claims raised in this case, because anything that went to acts that would be immune under this statute can't be used to support, for example, claims of intentional infliction of emotional distress or essentially false imprisonment. All of the claims that are made in this case are essentially going to have a lot of evidence that comes out of the hospital's conduct that is more likely than not immune. So that creates a problem for the appellate court in spelling all of this out. So why don't we go and skip to the bottom of the ticket here, and I will explain what the court eventually ordered here. So this is the end of the actual opinion, the first part of the opinion. It's not the concurring opinion. And essentially what they decided was that with respect to the intentional infliction of emotional distress, such that it caused Mrs. Kowalski to kill herself, that the actions weren't targeted at her. They simply weren't. And she did not experience anything in terms of them doing anything directly to her. Everything occurred to her child, and she can't claim emotional distress for things that she didn't see or hear. Then it comes to the false imprisonment. Again, they were carrying out their orders under the statute. They can't be held liable for that. Where they can be held liable for is for intentional infliction of emotional distress on behalf of Maya, some remaining false imprisonment claims, battery, and medical negligence. So that's what the trial court now has to piece together a trial and parse through the evidence that can be allowed with respect to each of these items of evidence and each of these claims. That's going to be a very difficult job for this judge. But to make things a little bit easier, the concurrence essentially concurs that the result was wrong for a number of reasons, most especially because of the immunity issues. But it says that Maya's claim for intentional infliction of emotional distress, the actions, in a nutshell, what the concurring opinion says is at baseline, the hospital's actions in essentially telling the husband to, go find another wife, or that Maya was going to have, this woman be her mommy. Some of the things that were said to her by the nurses, all of those reached the standard of being outrageous. So Maya's intentional infliction of emotional distress claim remains. More likely than not, if the plaintiffs are smart, that's the only claim that they are going to bring forward when they go back to retry this, and they're going to have to be very careful about what evidence they admit, and that evidence has to not shine a light on anything that's covered by the immunity provisions. And frankly, I don't know how they're going to do that. I have to say, I would never have taken this case. I'm a plaintiff's attorney. I believe in representing people who have been harmed by medical negligence and medical things that are done poorly. But the problems of proof here are so significant. By the time the trial came around, she was walking and doing things and ice skating or whatever it was they said she was doing. I mean, that's a pretty clear indication that Mrs. Kowalski was the problem, not the hospital. And so the intentional infliction of emotional distress claims are going to be very difficult to carry forward with the evidence that they have. And in the opinion, they took a lot of shots at the plaintiff's attorney for being overzealous and for arguing in ways that were beyond the pale, according to this particular appellate court. So it'll be interesting to see what they do on this case. I will try and keep an eye on it, and I will let you know. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.